So, welcome to Darabase Meets, which is a set of fireside type chats where we engage with luminaries in the augmented reality industry from a range of different backgrounds. I'm Dominic Collins, I'm the CEO and co-founder of Darabase, and today I'm delighted to be joined by Brian Wassom, who is an eminent lawyer across kind of trademark, copyright, First Amendment, especially where it kind of intersects with new media and new technologies. As you can see, Brian is sporting his Apple Vision Pro right now. So, are you going to stay like that, Brian, or do you want to switch into avatar mode?
Well, it seems to be appropriate to the subject matter to speak in an augmented way if we can. So let's see if we can make that happen.
Here we go.
All right. Here
Brilliant.
I
Well,
am in the virtual world.
yeah, I'm reality augmented. We're good to go. So, Brian, thanks so much for taking the time today. Do you want to give a bit of background? Because you've got an amazing background, probably a unique background in terms of what you do and the field in which you play and how that's really applied to the relatively short history of augmented reality. Why don't you give us a bit of background?
Sure. Well, I cut my teeth as a young lawyer representing traditional media outlets, newspapers, television, things of that nature, among other things. So I learned the media law space that way. But soon came to realize as a young professional, those media were dying out, and in fact, the companies that I used to work for now either don't exist or can't afford lawyers. So I set my sights for the rest of my career on media that was going somewhere, right? That was on the ascendancy and was just starting to become important. The things that I thought were going to be important in the coming decades, and I settled on augmented reality as a medium that was going to be the future, and it just struck me as inevitable on so many levels that this was going to be an important technology. So that was around 2008, 2009, 2010 time frame. Started to write and speak and blog about these ideas. Quickly got to know folks in the industry, started going to what is now the Augmented World Expo, meeting all the movers and shakers in the industry now, the people who are really making it happen, and started representing some of those companies and just kind of went from there. In 2015, I released a book. Reed Elsevier published a 400-page book that I wrote on augmented reality legal issues. 2017, I got to make some pretty interesting precedent that we can talk about, some legal precedent related to Pokemon Go and location-based AR games like that, and just pressing forward. Happy to be part of these teams. I'm under no illusion that I'm a technologist myself, but I'm happy to bring my legal perspective to be the lawyer on these teams, partnering with the people that are really pushing the technology forward.
Yeah, and I think actually this technology more than many others kind of needs that legal context because the physical world has got a long history in law, and as we start layering digital content onto the canvas that is the physical world, those two worlds start to intersect, and we go beyond just thinking about cookies to thinking about more property related legal issues and copyright and so on. So in terms of kind of those early days and that early precedent, everyone remembers Pokemon Go. In fact, a lot of people think that Pokemon Go was kind of a bubble, back in 2016 or whatever. I think it still made over $500 million last year, so this is by no means gone away. But I suppose it is a little bit of a kind of poster child for the location-based augmented reality industry. So, can you tell us a little bit more about kind of your time back then? What must be kind of 7, 8 years ago, and some of the work that you were doing?
Sure. Well, it's hard to imagine that much time has passed already, but yeah, you're right. In 2016, Pokemon Go took the world by storm. The AR industry was anticipating it. I think the rest of the world had no idea what was coming, and all of a sudden, large groups of people started to behave in ways in the physical world that were unpredictable and that were different than how they would normally behave and interact with physical infrastructure. And so this, quite understandably caught a lot of people off guard and unsettled some people. And municipalities, especially, were dealing with large herds of people wandering through public areas and interacting with the Pokestops that were in public parks and public buildings, things of that nature, since that's where Niantic focused its assets. And they obviously we have that many people and young people doing these sorts of things. Stuff happens. Daisies were trampled, access hours were violated in some instances. So, understandably, municipalities started passing rules or enforcing their existing rules about hours in accessing parks and not trespassing, things of that nature. All routine, rudimentary stuff, but just reminding people to behave in a way that respected their physical surroundings. Well, one city took that a little too far, and that would be Milwaukee in Wisconsin. And they passed a rule that purported to regulate the publishers of the games themselves, not the people playing the games, but the publishers of the games. And they said, you can't publish a game that takes place in our public parks without our permission. And they really did a ham-fisted job of drafting this regulation. It really was poorly written on a number of levels because they kind of shuffled video games on a mobile phone into the same category as holding a wedding in a public park, right? And getting permission, having to go through this whole permissions-based process to get access to the park. It was unworkable on a lot of levels. But from a legal perspective, I think the most damaging defect was that they actually purported to tell software companies what they could and could not publish. And that, to me, was a very clear First Amendment issue. The right to publish software is the same as speech. Software is expressive content. The government cannot tell you what the content of that software can be ahead of time. So I was all geared up and ready to go on this. All I needed was a client. Um, Unfortunately, when we as lawyers see legal problems, we can't just go out and sue them ourselves, right? We need to do it on behalf of someone. And I did not at that point have a relationship with Niantic, and they weren't inclined to do that. So I found some other did some searching around, and fortunately by that time I had been connected through AWE and through the industry, and managed to get in touch with a company who put out a very similar, functionally similar location-based AR game, and was willing to take this challenge on. And we filed lawsuit, and we were remarkably successful. We got a preliminary ruling and then a final ruling from the federal court striking this down, this regulation down on these grounds that we raised, and ultimately not only striking down the law, but ordering the municipality to pay our legal fees. So it was a complete win, and I thought just a really fun way to contribute legal precedent to the industry. So now we have this to point to that says, yes, the First Amendment, the right to speech, the breadth of that right and that freedom applies just as powerfully and just as broadly in the AR space as it does in any other medium.
So, and congratulations on that piece of work. It was quite literally groundbreaking. But I suppose on the flip side of the First Amendment is kind of the copyright and IP law. And actually, what came out at the same time was that companies like Niantic did actually choose to allow people to remove content from their private property or from near their private property in order to be able to kind of give the property owners a set of controls. And it feels to me that there's quite a difference as well in the way that we think about content being laid on the world, whether that's kind of editorial content, so the gameplay itself, versus commercial content, advertising content, and so on. Do you kind of see that distinction?
I do. I don't see what Niantic did as being a copyright or an IP issue as much as a real property law issue, and specifically trespassing, nuisance. These are all grounds that they were sued for right around the same time. This is in a different court. In fact, these lawsuits had already been filed by the time my case came around in 2017. But they were filed in the Northern District of California, where Niantic's located. And that litigation was pending for quite a while. It lasted a long time, just for procedural reasons, and there were all classes of people that sued Niantic, basically alleging that they were contributorily liable for the property damage that players were doing, right? That they had induced these people to trespass on their property, to trample their daisies, as it were. And the result of that case, there were some preliminary rulings that suggested that the court was perhaps open to those theories, which is understandable in some ways and unsettling in others. There needs to be some lines drawn around that. In this case, didn't draw them. I think probably for the best, but the negotiated settlement that came out of that case, I thought it was still interesting, because it's kind of private self-regulation, if you will. And Niantic, yes, adopted a policy through that settlement that said, if you, as a landowner, object to there being a Pokestop on your property, you can let us know, and under certain parameters, we'll honor that request. It also adopted voluntarily some distance limitations. It wouldn't put content so close to a residential area as opposed to more of a public or a commercial area. Things like that. Rules that I honestly, as a ongoing Pokemon Go player myself, I don't know that they entirely follow that same set of rules anymore, but I think the basic structure is still there. So that was, yes, you're right, that was interesting. But the second part of your question also is important, and it raises, I think, a separate issue when it comes to marketing. And that is that while there are these disputes between the right to publish and the rights of landowners, and there's some legal doctrinal conflicts involved in those arguments that we can talk about, but that is a distinct thing from the laws that regulate marketing, the laws that regulate commercial speech, which I think is one topic we definitely want to discuss. And so those laws, I do think, have application in the AR medium. And so the fact that software is speech, as the issue raised in my earlier case, that doesn't give you the complete answer to the question, right? That was government versus publisher, and in that realm, the publisher, if it's a free speech issue, they're going to have that freedom to publish. But if they're publishing commercial content on that platform, and it infringes the rights of other commercial entities, there's a remedy for that, and I think those remedies will apply in the AR medium.
Yeah, I think it's an AR. Actually, even so, we had a case. We're seeing an increasing amount of what is being called faux out of home, though it's kind of faux AR. So basically, images or videos of cityscapes normally, and someone's used CGI to kind of place some commercial content onto the city scene, and then it's shared on social, kind of like it was there. There was a famous one recently where a cosmetics brand put a big eyelash on the front of a tube train in London and put a mascara there. You may have seen that. And there was one at a big sports event a couple of weeks ago, big rugby event, which is sponsored by Diageo and Guinness, where a competing beer brand basically put their beer over the stadium instead. It wasn't actually even in augmented reality. It was just through this kind of CGI, this kind of fake augmented reality. But it was clearly creating kind of an implied endorsement. It was cleaner, what I would kind of think of as passing off, so that there was an association being made with the property, with the location, and by that particular brand. And I think there's the Lanham Act, right, in the States, which kind of addresses something similar. Can you just kind of talk a little bit more about that, Brian?
Sure. And that's where the unanswered questions still lie and where the boundaries are between that. But you're right. The Lanham Act is our trademark act in the US. And it, sets down the rules of uh, how you can limit or what the boundaries are in commercial speech in terms of how you advertise your brand in relation to other people's brands. And there are a number of different theories, be it false advertising, trademark infringement, trade dress infringement, unfair competition. These are all labels given to different causes of action, but they all have the same underlying legal uh, analysis that goes into them, and that does this speech create a likelihood of confusion? And the target audience being the consumers receiving this messaging. And the question asks, as a result of this speech, will potential consumers who see this messaging be confused as to the source of the goods or services that are being advertised? Will they be likely to either not be able to discern where they're coming from, or to mistake that it's being advertised by one entity versus another? And if that's the case, if it creates a likelihood of confusion, then the trademark owner or the business that's being affected by the speech has a legal cause of action. So, in your example, in the stadium example, then the question applying these principles would be, well, is the author, is the publisher of these augmented balloons, they're seen by the consumer as floating over the stadium, does that create in the minds of consumers a likelihood of confusion as to whether or not the stadium owners, the team itself, endorses that brand or has an affiliation with that brand? And if the answer to that question is yes, well, then there's an argument that that's now infringed trademark, or at least amounted to some sort of unfair competition.
Sure. And how do you see this kind of developing further? Because obviously you're I've almost forgotten now, but you're sitting there in your Apple Vision Pro. I'm sure many people have seen a bunch of different videos of people walking around the city like Casey Neistat and whatever wearing this. And whilst it's not designed to be like a pair of smart glasses to kind of augment your day to day as you wander around the city, we're clearly moving in that direction probably faster than many people realize. So, and I suppose the law, whilst it seems to be catching up more quickly, tends to lag behind the technology. So kind of as with your kind of lawyer hat on rather than your technology hat on, as you look at this kind of mid to long term future, the next kind of 5 to 15 years, what do you think is going to happen from a technical perspective, and how do you think the law will or needs to be able to respond to that?
Yeah. So I think that the important development that will happen, when is hard to say, because when I first got involved in the industry 15 years ago now, we all saw things like this Vision Pro happening in the next 2 to 3 years, right? And that obviously took a lot longer, and people have been consistently frustrated with the slow pace. There are good technical reasons why it's been slow, but nevertheless, so putting a number on it is tricky. But the direction we're moving in, and the destination that we're a lot now closer to, is a general shared augmented reality, a shared layer, shared digital layers, that any publisher can come and put content on, any user can put content on, and it'd be like a three-dimensional version of a social media platform like a Facebook or LinkedIn or Twitter or whatever else, where it's one shared platform, one shared reality on which anyone can put their digital content. When we have that shared platform, now the possibility of likelihood of confusion becomes a lot greater. Right now, the example you gave, especially since it was really just CGI, is a unique case. And even if it were true augmented reality, the only way people would experience it is by opening a particular app that was designed probably by the same beer company for the purpose of being able to visualize those balloons. And they would open up that app and hold up their phone expecting to see those balloons. So it's a walled garden. Every app, every experience, every AR experience is a walled garden. And people go into it knowing what they're going to see. So it's difficult for me to see a case that overlays in that environment create a likelihood of confusion, even if the thing being overlaid is done without permission of the physical landowner, right? Because it's it it may be a commercial expression. And in a particular case, who knows? There might be an argument that says, "Oh well, consumers assumed that this app had permission to do that." Maybe it's just harder to do. But if we all have a eyewear that we can walk around, yeah.
I was going to say, I think there is an interim step which is happening already before we kind of get to this single platform where everyone can, be a part. Where, for example, Google's geospatial API is making it much simpler for developers and brands to start to create editorial content, games, tourism, whatever it is. I think there was something like 2,700 developers entered the geospatial API competition before Christmas. So, the likes of Google and Meta and others are making it ever simpler to be able to create, these world scale, location-based augmented reality experiences using visual positioning systems. And whilst the main experience to your point, which I think is a good one, that you're opening up is, hey, I'm going to go, explore the city. I'm going to go shopping. I'm going to catch a dragon, whatever it is. They're going to need a way of monetizing that audience in the same way that applications have since, and websites and media forever. And so they're going to want to be able to plug in some kind of commercial advertising, SDK or plugin. I'm kind of talking about Darabase here specifically, but I'm no doubt there will be others too. And so, yes, I'm walking down the road and I've opened this application expecting to catch dragons, but I'm then going to start seeing commercial content in my field of view on buildings or whatever. So I think there is quite quickly an interim step where what I'm doing isn't a walled garden expectation around the commercial content, and the commercial content has been inserted into my field of view, and that needs to be done with permission.
Sure, you're right. There are going to be those transitional species examples, and I think that one's a good one. And the Pokemon Go platform that we talked about is starting to show examples of that as well, right? Yeah. For the past few years now, there have been sponsored Pokestops. Every Starbucks is a sponsored stop now. There have been more direct examples of advertising in the game that you can interact with in an AR manner. And they've come up with some really cool and fun ways to use that medium to advertise to their audience in an unusual and engaging manner. So yes, that to me are the early prototype examples of that. Even on this Vision Pro, just a couple of days ago, they announced that it's going to support WebXR. Right. And so if you can then use this device to access XR content just out on the web, well, the web is your quintessential shared platform. So yeah, that could lead to some interesting examples as well.
I've also seen people pairing their Vision Pro with their iPhone, so they use their iPhone as a way of understanding the world around them, the visual positioning system, and the scanners and whatever, and the camera on this device, and then they're using that paired with their Vision Pro so that they can start to then place content into the scene in a convincing way, ahead of the Vision Pro type devices being able to do that themselves. So yeah, people are finding routes around the technology already, which is exciting.
Yeah, it's still going to be a long time before I walk down the street wearing something like this,
sure.
But we're getting there.
Yeah, I mean, if nothing else, you're going to get mugged. So back to your point. So yes, we are going to be kind of moving into this world, which is more at an operating system level, I suppose. That whereas today, the way that we use our mobile phones is very kind of binary. It's one thing at a time. I check my Facebook or whatever. I look at my email. I go play a game. It's kind of one thing. And yes, they're kind of all layered, but actually, I can only see one thing on the screen at once. Whereas we become, get into a truly layered experience with wearables in the future, where I can have multiple things on at a time, and so back to kind of your points. How do you think the law will change in order to start to address some of those things?
Hmm. Well, by and large, it won't necessarily be the law changing. It will be changing our understandings and applications of well-established legal principles to this new medium, right? That's how the law develops. That's classic. So when the internet first became prominent, right, we had the same questions. Oh, that we've got to come up with internet law now. And like, no, there are some unique test cases and some unique statutes that were adopted, but by and large, it's okay. We've got these well-established copyright and other principles, and how do they apply to these fact patterns? So it'll be the same here. There may well, and I would kind of expect there to be some legislative additions to the law when it comes to interaction between digital content, augmented digital content, location-based content, and the rights of real property owners. We've mentioned that this is a speech issue, but speech isn't absolute. It's a fundamental right, but there are always boundaries on everything. And there have been efforts to legislate some sort of rights for landowners to control, what digital content people can put on their property. And so I expect there to be those types of laws, and how those turn out, whether they survive scrutiny or not, remains to be seen. But yeah, otherwise, I think things like the Lanham Act are going to have a lot of application, because the first examples of augmented content that people interact with are going to be commercial, right? You follow the money, and people are going to develop this technology because it makes them money. And when money is being made, that's when people get, engaged enough to actually file lawsuits.
And what are you most excited about in terms of technology for the future? Maybe it may not be augmented reality. It could be something else. As you kind of think about, you as a person rather than as a lawyer and as a father, and going out with your kid playing Pokemon Go or whatever today, how do you think this will evolve? And what I suppose what most excites you, and kind of what worries you most?
Well, I'd have to say the same things worry me and excite me, right? I do. I am really enchanted by this idea of the augmented reality shared experience, right? Not when it's flashy and visible like these Vision Pros, but when it becomes subtle, right? When we get to AR contact lenses, for example, or glasses that are actually wearable, and we're interacting with digital content in ways that isn't overwhelming, isn't flashy, but that it's useful and it's subtle. If I'm walking down the street and I walk past a restaurant, for example, I want to see the menu virtually on the outside of the wall, and I want to be able to virtually touch a button and put in my order that way, rather than pulling out a phone and doing this, or standing in line. Just little things that make the world more efficient and interactive and interesting, right? Like buttons and bubbles that pop up and tell me about the things that are around me. A work environment, I've done a lot already in talking about Apple Vision Pro as a productivity device. I want to see more productivity aids in my office, but at the same time, those things all worry me, because as a parent, I see my kids and other kids getting too invested in digital technologies, right? They can't live without screens for too long. They are, I think, not developing the same skills that we had to learn by interacting with the physical world, or real print books, things of that nature. So there are thought processes and skills that I think they're missing out on. And when people get too used to the idea of everything being around them digitally, I think the potential for being disconnected from actual reality is a lot greater, and that won't be a healthy mental place for some people to be.
Yeah, and I think my hope, and certainly what we're trying to achieve, is to help create a future where the reality bit is the most important bit, but it's augmented. Like some of the examples that you've made. The last
Mhm.
company I worked in, which was Jaunt, which was mostly a virtual reality company. I just when I decided what to do next, I very much wanted to kind of go into AR rather than VR because I just think one, the potential is way bigger, but two, it's just
Sure.
I'm going to use a terrible term here, but it's just a nicer technology. I think it's a technology that promises to augment humanity rather than kind of make it more distant. And I kind of
Mhm.
hope that actually spending less time looking at small screens and more time looking at the world around us, but then having those moments of delight or insight or whatever that technology can deliver contextually in location will actually make us more sociable and will give us better skills and Niantic from the get-go has always been, look, we're a technology company, but we want people to walk around, we want people to get fit, we want people to experience the world. And I think that
Mhm.
is the opportunity we have in front of us. And hopefully we can learn some of the lessons from the last 10, 15 years and apply new solutions to this new technology.
I'm 100% on board with everything you said. That's why I prefer AR as well. And Tim Cook has said it a number of different ways. He explained, in great detail those reasons why AR as a medium has a much longer road ahead of it and why it has, more social benefit. And I really respect what Niantic has done along those lines too. They've been very adamant from the beginning, from John Henke on down, in insisting that their goal was to get kids out in the real world and to use technology to do that, right? And they've left money on the table in sticking to those rules, right? They recent innovations to the game that during COVID that would have made it a lot easier to just sit on your couch and play the game, but
Yeah,
they left that aside, even though it was profitable, because they wanted kids to get outside. And I think we need more people thinking about AR and related digital technologies, mobile technologies in that way.
absolutely. Brilliant. Well, look, Brian, thank you so much for your time. Any last thoughts or comments before we close?
No, just that I'm glad that you're keeping this conversation going. I appreciate you inviting me and inviting everyone else that you've had on this platform, because these are things I think that we really need to start talking about. And there are those few of us in the industry that have been talking about it, but now I think is a really unique opportunity to start broadening that discussion.
Brilliant. Brian, as ever, great conversation. Lovely to see you again, and have a great weekend.
All right, you too, Dominic. Take care.
Thanks, man.